The court. My name is Christian Velazquez, and along with my co-counsel, Isaac Yu, we represent the respondents, Janice Madrid and Richard Williamson. The issue presented in today's case is whether Ms. Madrid and Mr. Williamson violated the Fourth Amendment of Ms. Torres, specifically the right to secure against unreasonable search and seizure, and whether or not the attempt act to seize Ms. Torres constitutes as a seizure under the Fourth Amendment standards. Will the court benefit from a brief recitation of the facts?
Yes.
On July 15, 2014, in Albuquerque, New Mexico, officers Janice Madrid and Richard Williamson set out to arrest Roxanne Torres near an apartment complex. Ms. Torres, who was standing near her vehicle at the time, was under the influence of methamphetamine. As both officers approached, Ms. Torres made the hasty decision to enter her vehicle. Ms. Torres was under the false impression she was being carjacked and did not realize both Janice Madrid and Richard Williams were officers. After Roxanne decided to take flight, both officers drew their weapons and began firing at the vehicle. Two bullets penetrated Ms. Torres, but she continued to drive away. Later, she obtained a car and drove 75 miles more to a hospital and was then arrested the next day. Torres then sued Williamson and Madrid for violating her Fourth Amendment rights. Torres argued that the officers used excessive force to seize her. The district court concluded that the officers had not seized Torres at the time of shooting, and without a seizure, there could not be a Fourth Amendment violation. The court concluded that for a seizure to occur, it would require for the subject's movement to come to a halt, and neither shall result in the halting of Roxanne Torres. Therefore, no seizure took place. Ms. Torres then requested a hearing at the Supreme Court and was granted the opportunity. My co-counsel and I will be addressing the issue by arguing 3 points. First, adhering to constitutional and judicial precedent. Second, English common law principles concerning arrest do not approximately apply to contemporary Fourth Amendment standards. Third, the portions of Hordari D opinion that cite common law principles which are cited by the petitioner are non-binding and non-presidential dicta.
Concerning the first issue, involving this court's necessity to adhere to constitutional and judicial precedent, the unsuccessful attempt to restrain Ms. Torres by officers Madrid and Williamson does not constitute as a seizure under the Fourth Amendment. The Fourth Amendment states, quote, "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized." In the case of seizures, in accordance with this principle, this court has established a clear precedential line to distinguish what does and does not constitute as such. Perry v. Ohio states that whenever a police officer accosts an individual and restrains his freedom to walk away, it seizes that person. Additionally, according to the United States v. Mendenhall, this court should, quote, "adhere to the view that a person is seized only when, by means of physical force or a show of authority, his freedom of movement is restrained, and if, quote, in view of all circumstances surrounding the incident, a reasonable person would have believed he was not free to leave." All of these aforementioned requirements are not fulfilled in the case at hand. While officers Madrid and Williamson did perform a clear sign of authority in the form of direct orders and eventual gunshots,
Was the police officer's shooting of Torres reasonable?
Yes, Your Honor. Ms. Torres started a vehicle, and the officers were directly in line of the vehicle's movement, and they had adequate reason to believe that their lives were potentially in danger. Ms. Torres still refused to comply with their demands at halt, to the extent at which she was able to evade arrest for an entire day and travel 75 miles away from the site of the incident to do so. Torres did not even realize she was being confronted by law enforcement at all, as she was under the influence of methamphetamines, and instead she feared that she was being carjacked, and thus felt that she had the right to flee.
Forced the Hordari to a halt. Since Hordari did not comply with the injunction, he was not seized until he was tackled and successfully apprehended. Similarly to the use of a roadblock to stop flame perpetrated in the case of Broward County of Inyo, was only deemed a seizure under the Fourth Amendment because the court decided that the roadblock was not as significant a show of authority to induce a voluntary stop, but also designed to produce a stop by physical impact if the voluntary compliance did not occur. An intentional question of physical control. Again, since the officers did not obtain physical control of Torres, nor did she yield to their clear show of authority, the officers' actions of firing gunshots at the fleeing Torres does not constitute as a Fourth Amendment seizure, according to the judicial precedent set by the court. Moving on to my next point, in his initially proposed version of the Bill of Rights, James Madison inscribed Article the 6th, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by the oath or information, and particularly describing the place to be searched and the persons or things to be seized, which will soon be developed into what would become the Fourth Amendment. In order to properly interpret medicine and the Founding Fathers' initial intentions and understandings concerning the Fourth Amendment, it is necessary to harken back to English common law in regard to said amendment, as Payton v. New York states that examination of the common law understanding of an officer's authority to arrest sheds light on the obviously relevant, if not entirely dispositive, consideration of the farmers of the amendment might have thought to be reasonable. When examining common law cases in which mere touch arrests are involved, it is erroneous to consider them as seizures in the manner cited in the Fourth Amendment, as they are constructive arrests that serve uniquely distinct purpose than the one that applies in today's case, and its usage is conspiratory society.
For instance, in the case of Anonymous, 1676, the court decided that when, quote, a bailiff caught one by the hand through a window and was such a taking of them, that the bailiff might justify breaking open the house and tearing away. By this, the court did not imply that merely touching an individual constitutes a full arrest or seizure, but instead is used figuratively as a hypothetical to justify and permit law enforcement to force entry when performing their necessary duties. Additionally, in Archibald treaties, if a bailiff were to fail to retain an individual until they were, quote, delivered by due course of law, then they were liable for monetary damages and compensation to the plaintiffs. Therefore, while judges of the time designated constructive arrest precedents that permit bailiffs to perform their duties adequately and properly ascertain civil liability for bailiffs that failed to perform said duties, these legal notions were not intended to define the terms and conditions that constituted an accident seizure, as it is referred to in the Fourth Amendment and as it is applied in this case. So in essence, as California v. O'Darry v. states, quote, neither usage nor common law tradition makes an attempted seizure a seizure. Thus, common law tradition cannot and should not be applied to this case. And finally, considering our final point, the portions of O'Darry v. that cite common law principles are non-presidential dicta. Another major issue of contention that must be taken into consideration today is the legitimacy of the portion of Justice Scalia's majority opinion in the case of California v. O'Darry that is cited by the petitioners, and whether or not this court should consider it as holding precedent or mere dicta. In order to properly address this, one must evaluate the facts and circumstances surrounding the case of O'Darry v. and the legal definition of dicta itself according to this court's precedent. Firstly, the definition what constitutes dicta is stated in rate that defines dicta as, quote, statements and comments in an opinion concerning some rule of law or legal proposition not necessarily involved nor essential to the determination of the case at hand. This definition is affirmed by many other Supreme Court cases like Humphrey's Executor v. United States and Central Virginia Community College v. Katz, both of which recognize dicta as non-binding. Conversely, a binding ratio decidendi statement is only so if it is the legal doctrine and reasoning that is pertinent to the decision, judgment, and facts relating to the case.
Regarding the sections of O'Darry v. opinion in question, it addresses common law doctrine concerning Dickinson area arrest, primarily in the effort to differentiate from contemporary legal doctrine and demonstrate that attempted seizures do not apply under the Fourth Amendment standards.
Did California v. O'Darry hold that the Fourth Amendment encompasses the common law definition of arrest?
Even though California v. O'Darry mentions common law, it makes a clear distinction between both common law and the modern representation of the search and seize of the Fourth Amendment. This discussion surrounding these common law cases and concepts are non-essential and had no substantial bearing upon the ultimate ruling for O'Darry v., nor did it relate directly to the facts of the case, and therefore, by definition, are dicta and should not be considered as binding precedent, nor override other presidential and binding standards like those stated by Brower, Menha, and Terry when concerning seizures. Many other lower appellate courts have also already correctly adopted this notion, as in the case of Brooks v. Ganzo, in which the 10th Circuit completely dismissed the common law aspects of seizures mentioned in O'Darry v. as dicta and said based its ruling on the standards established by other aforementioned case, as the court explicitly states judicial precedent does not stand for the proposition that use of deadly force alone constitutes a seizure, and said a clear restraint of freedom of movement must occur. The case of County of Sacramento v. Lewis also states that a police pursuit is obtaining to seize a person does not attempt a seizure within the meaning of the Fourth Amendment. Likewise, this court should correspondingly further this notion and acknowledge the common law discourse and doctrine mentioned in her diary as mere obiter dictum, and instead adhere to necessary aspects of control required by other presidential destinations of the Fourth Amendment seizures established by the likes of Brower, Mendenhall, and Terry.
In conclusion, while George Mason stated to, quote, seize any person or persons not named, or whose offense is not particularly described and supported by evidence, as grievous and oppressive and ought not to be granted, the Virginia Declaration of Rights, which is a statement as a core tenet of our legal history, the parameters of what constitute as a seizure, as such, is crucial for this court to determine. This court has already established a clear precedential line for the evaluation of Fourth Amendment seizures, and that they must require an intentional acquisition of physical control to be deemed as such. Therefore, the aspects of common law doctrine discussed in Hidari v., or that lay reference to common law mere touch arrest, should be considered obiter dictum and have no bearing on this court, and should not be the standard under which seizures are analyzed. It is nonsensical to deem Petitioner Torres to have been seized when respondent's gunshots pierced her, since she was still able to evade authorities for an extended period of time before being successfully apprehended. Were this court to deem mere attempts to restrain perpetrators using physical force as Fourth Amendment seizures, this court would set a dangerous precedent that would compromise the effectiveness of contemporary law enforcement practices, putting the lives of both law enforcement officers and perpetrators themselves at risk, creating unintended loopholes involving the Fourth Amendment's aspect of seizures, and being unnecessary to adequately address the issues concerning the use of excessive force by law enforcement. Instead, we ask this court to reinforce the decision of the 10th Circuit Court of Appeals and its own judicial precedent, and deem acts of physical force or authority Fourth Amendment seizures only if the individual is successfully apprehended as a result of said actions.
It is for these reasons that we pray that the court rules in favor of the respondents and affirms the decision of the 10th Circuit Court of Appeals.